speaker. So today we have Jake Davis with us. He is an attorney with the Nonhuman Rights Project, and in just a moment, he's going to tell us a little bit about what the Nonhuman Rights Project does. Some of his work includes litigating for freedom for non-human animals, specifically elephants, cetaceans, and chimpanzees. And he is the lead attorney in Hawaii, Michigan, and soon Pennsylvania. So without further ado, I'm going to hand the mic over to Jake.
Thank you, Savannah. I'm really excited to be speaker number one for this chapter of the bar. Hopefully, I will do the chapter justice. So, as Savannah mentioned, my name is Jake Davis. I'm a senior staff attorney for the Non-Human Rights Project. I'm based in Wasilla, Alaska, and I have colleagues throughout the country. We have attorneys in New York, we have staff in California and Oregon, so on and so forth. But this presentation is going to be called Securing Freedom for Non-Human Animals Through Habeas Corpus. So what is the Non-Human Rights Project, or as we call it, the NHRP? Well, we were founded by attorney Stephen M. Wise in 1995, and we're the only organization in the U.S. dedicated solely to securing legal rights for non-human animals. Without rights, these animals are legally invisible to the courts. In other words, their interests or injuries just don't seem to matter unless they are tied to a human interest or injury. Unfortunately, Steve passed away last year after a multi-year battle with brain cancer, but he certainly was a voice for all animals, and um, I think, will go down as being credited with making animal rights a reality in the legal profession. Time will tell, but he's certainly one of a few names who should be honored at some point um, with that life achievement. Our mission is to challenge an archaic, unjust legal status quo that views animals as things with no rights, and we urge courts to uphold and strengthen our most cherished values and principles like justice, liberty, equality, and fairness by extending rights to non-human animals. We also urge courts to help ensure that our legal system is free of bias and arbitrary reasoning. But that in of itself may be a bit of a fool's errand. I think there will always be some bias in the legal system, but we are working to limit it for non-human animals. There are a couple key aspects to our approach, and one of those aspects is state common law. If there are any attorneys um, on the call, you may understand what the common law is, but for those who do not, it's judge-made law and it's meant to evolve with the times. Before we brought our very first case in 2013, the staff of the Non-Human Rights Project at the time, they spent years researching what would be the most viable forums to bring the types of cases that we bring. And we actually have an internal document that has all 50 states listed with pages and pages of information on those states' common law. And some of the themes that I mentioned in the past slide, like equality, justice, fairness, and what courts say about those terms in the context of the common law. But we determined ultimately that New York would be the best first state for us to litigate in because we thought it would be most favorable to our arguments. And that would prove to be right, as we will see later in this presentation. Another key aspect of our approach is habeas corpus. Again, for the attorneys on the line, you may understand what habeas corpus is, but for those who do not know what habeas corpus is, it's a centuries old means of testing the legality of an individual's imprisonment before a court. It's known as the Great Writ, and it was used historically to help children, women, and enslaved human beings whose captivity was not in violation of any statutory law, but whose captivity was unjust, and even against the statutory law of the time that permitted certain actions toward those groups of people. Habeas corpus was able to be used to prohibit those activities. And so it really is kind of a special legal proceeding. It's called the Great Writ for a reason. It can cut through aspects of the law that other writs, other causes of action cannot. And it's still used today frequently. You may have heard it brought up in the news not too long ago. I think there were some threats from current administration about eliminating habeas corpus opportunities for some, but I don't think that would ever stand. And the quote on that sign the woman's holding, "Let justice be done, though the heavens may fall," that is a quote from one of the more famous habeas corpus matters in the English world. It's a quote from the case of Somerset versus Stewart. And Chief Justice Lord Mansfield, who was sitting on King's Bench, which was a court in England in the 18th century, he said, Fiat justitia ruat caelum, and that is Latin for "let justice be done though the heavens may fall." And when he said that, he then freed the slave James Somerset from captivity. And as far as slavery goes, the rest is kind of history. That was kind of the first real legal decision contrary to the slave trade of the time, and it laid the groundwork for the abolition of slavery to come later. Another key aspect of our approach is legal personhood. Under existing law today in America and in most English-speaking jurisdictions, you are either a thing that has no legal rights, or are a person with at least one legal right, or the capacity for a legal right. But there really isn't a third option. And legal personhood is somewhat of a contentious phrase. It does not mean human. It's not synonymous with human or humanity. This is something that judges oftentimes struggle with. Even the most learned legal professionals struggle with the idea that that the term person is not synonymous with human. But excuse me, it's a point that we continue to make in our pleadings. As of today, no non-human animal in the U.S. has been recognized as a person for the purposes of habeas corpus relief, specifically recognized as a legal person for purposes of habeas corpus relief, although this type of recognition has occurred internationally. We are regularly reassessing how personhood figures into our arguments for the very reason I mentioned, which is it's just such a loaded term. It immediately evokes an image of humanity or humans, and so it's a very challenging concept to explain to judges who are somewhat biased based on terminology alone. We'll come back to legal personhood a little later in the presentation. Another key aspect of the NHRP's approach is our scientific evidence. Our cases rise and fall on the scientific testimony that the world's foremost elephant and chimpanzee experts submit in our cases. They submit their testimony through declarations and affidavits. And again, I can't reiterate this enough. Our cases would not be possible without these individuals agreeing to assist us. Some of the key words that we like to focus on are self-awareness, autonomy, and cognitive complexity, because those are the words that our experts use in drawing conclusions about our elephant and chimpanzee clients. Now, elephants, great apes, and cetaceans, who we hope to bring our first case on behalf of next year, aren't the only animals who are suffering, but we consider them the most likely to be the first individuals to break through the legal wall that separates humans from non-humans. And that is because we can speak about elephants, about chimpanzees, hopefully soon about orcas in a way that's very similar to how you and I talk about other people. These animals experience the world in much the same way we do, arguably in a heightened sense. And so those type of comparisons aren't what we hope will carry the day because they are unique to humans, but they are a talking point that can interest judges and other people who are following our cases. If it's wrong to put a person in jail arbitrarily because of the things that we need to thrive, then it's the same reason as to why it's wrong to put an elephant or a chimpanzee behind bars, because they need certain things out of life to thrive, and those things cannot be met. They cannot acquire those things when they are behind bars. It's also worth mentioning that the scientific evidence that we have been submitting in our cases since 2013 has gone unrebutted, and judges do seem to find that scientific component very compelling. Um, it's not a prerequisite for judges to find anything compelling, but they seem to find the scientific evidence very compelling, which is good because that is what underlies our lawsuits. So some of the key obstacles that we encounter are some of the following refrains, including only humans can have rights, which really is another way of saying human exceptionalism. Human exceptionalism is the idea that humanity is exceptional at the sake of all other species. Granted, we are an exceptional species. There's no debate there, but that doesn't mean that we need to treat other species as less than. Um, we encounter the obstacle that sanctuary is still a form of confinement. So in a habeas corpus matter, you have to let me back up. In a habeas corpus matter, typically you seek ultimate relief from the confinement that you are in when you bring the habeas corpus case. Some judges seem to think that you can only seek ultimate freedom through a habeas corpus petition. But the reality is, habeas corpus allows for creative relief There are examples in every state we litigate in where individuals seek their relocation from, let's say, a county jail to a state prison, perhaps from one part of the prison to another part of the prison, perhaps from a jail to a hospital, from one room in a hospital to another room in a hospital, from prison, obviously, back to the streets, back to freedom, from a hospital, the same. But the point is, you can go from one form of confinement to another through a habeas corpus petition. So the idea that sanctuary is still a form of confinement when it is night and day with the zoo environment and private captivity we see our clients in is just a matter of being wrong on the law. And it's frustrating when judges make this statement because it is wrong and we provide the case law that tells them it's wrong. So I am not sure why we continue to hear that sanctuary is still a form of confinement. We haven't heard it much lately, but it was certainly something that we heard years ago. Perhaps we're just getting better at arguing our cases in the papers. We also hear that our types of cases are matters for the legislature and that the courts shouldn't weigh in on these important or contentious issues. We hear that our case will result in a slippery slope. If we free a chimpanzee or if we free an elephant and we move them to a sanctuary, what's to stop everybody in society from coming to the courthouse doors tomorrow and bringing a case on behalf of you enter the animal name? That's also called the floodgates argument, that relief for one means relief for all. That's simply not how habeas corpus works. Habeas corpus is inherently a case by case assessment, which is why we bring the cases in this manner in the first place. So the court has to focus on the individuals who are listed in the pleadings and nobody else. Judges consider themselves bound by precedent, and obviously we encounter standing and jurisdictional issues, although those are becoming more infrequent. Some progress from the NHRP. Our first cases were filed on behalf of chimpanzees, specifically in 2013. Our very first case was filed on behalf of a chimpanzee named Tommy. He was being held in a, well, you'll see the type of environment he was held in an image in one of the slides coming up. But he was privately owned by an individual who ran a used trailer lot, and he just kept Tommy in this cage in one of the back rooms of his office. Tommy had a TV in his enclosure. He had a couple like soiled blankets, and that was it. He was on cement, nowhere for him to climb, really nowhere for him to move to. There was no form of enrichment or entertainment aside from a TV that had a cartoon on a loop. It was a really bad situation, and I'm glad that the NHRP at the time identified Tommy as our first client because his story is really compelling. He was abused prior to being relocated to this trailer lot where we found him at. He even was featured in a couple small films, but yeah, he didn't know much by way of love or consideration, and never did. He ended up passing away in captivity because we did not prevail in the case, but his name is now out there, and we certainly, you know, hold his memory close at the NHRP. I'll speak more about Tommy later when we get to some of the cases that we have ongoing. One of them we brought specifically to try and get Tommy out of his captivity that he passed away in. But anyway, chimpanzee clients Hercules and Leo were the first non-human animals to have a habeas corpus hearing, and that was in 2015. Hercules and Leo were being held at Stony Brook University in New York. They were being used in locomotion research. They didn't have much of a life. They were in a basement lab, no natural lighting. They were, uh, yeah, they spent their whole life there. They had electrodes hooked up to them during the working hours and forced to walk upright. Chimpanzees don't often walk upright. So I'm sure it was a strain to get them to do that every single day, just to test how locomotion evolved to humans. And when that first habeas corpus hearing was had, the justice overseeing the case, Barbara Jaffe, wrote in her opinion, isn't it incumbent upon the judiciary to at least consider whether a class of beings might be granted a right or something short of the right under habeas corpus law? And I think that's a powerful statement. Um, and I realize I need to backtrack just slightly again. Habeas corpus is a unique procedure. When you bring a habeas corpus petition, two things have to happen before ultimate relief is granted. The first thing is the writ or the order to show cause needs to be issued. That basically starts the case in earnest. It's different from civil litigation where you file a complaint and then the opposition is noticed and then they file an answer and you file a reply. With habeas corpus, the case doesn't begin until a judge issues an order to show cause. So what happens is you file a habeas corpus petition and the judge reviews that petition. Now, the judge is required in every state in the US and everywhere that habeas corpus is used to assume the truthfulness of the allegations. And in assuming the truthfulness of the allegations, if they feel that relief could be granted, then they have to issue the writ. When the writ is issued, the opposition gets an opportunity to file a reply, a response, I should say. And when the writ after the writ is issued and the response is in, and then the instigating party has responded to that response, a hearing is held. And so that's where we were in this case. The writ was issued, we had the responsive pleadings, and then a hearing was had. And this doesn't happen in every habeas case because sometimes the court just dismisses the petition outright. So you don't even hear from the opposition, you don't get a chance to argue in front of a judge. They just say, no thanks, don't want to hear the case, goodbye. And so that's the unique aspect of habeas corpus. There are two steps. The writ is issued, and then hopefully the writ is granted. Well, the writ was issued in this case, not ultimately granted, but Justice Jaffe did agree with us on standing. We had standing to bring this case on behalf of Hercules and Leo, and she rejected the slippery slope argument or the floodgates argument. And she said that that type of hysterical argument is not a cogent reason for denying relief. Courts are supposed to handle cases. They're supposed to handle an influx of cases if they make a decision that is contrary to what has been. It is the nature of courts to decide cases. So Justice Jaffe has become a supporter of ours in retirement. She actually sent me a message on LinkedIn just the other day about a blog I wrote regarding this hearing. We were doing like look back at the NHRP, and so I wrote a blog looking back at this watershed moment, the first habeas corpus hearing. And she reached out and said she really appreciated the kind words. So it's cool to see judges engage with our work after the fact. I just wish she would have gone a little further in this case. So the case we brought on behalf of Tommy was consolidated with a case that we brought on behalf of another chimpanzee, the fourth chimpanzee that we initially sued on behalf of. His name was Kiko. Those cases were consolidated on appeal, and we took that appeal to the New York Court of Appeals, which is confusingly named, but the New York Court of Appeals is the highest court in New York State. So it's the equivalent of the Hawaii Supreme Court. And we sought leave to appeal the case in front of the Court of Appeals, and the court ultimately denied us leave, so we were not able to brief the case in the New York Court of Appeals. But in denying us leave, one of the judges on the New York Court of Appeals wrote a concurring opinion, and this is incredibly unique situation. We actually worked with a New York Court of Appeals researcher, and as far as he could tell, this was the only time in the court's history that a concurring opinion had been authored on a denial of leave decision. And the New York Court of Appeals has been around since 1847, so quite a long time. And in that concurring opinion, Judge Eugene Fahey wrote that non-human animal rightlessness is a deep dilemma of ethics and policy that demands our attention. To treat a chimpanzee as if he or she had no right to liberty protected by habeas corpus is to regard the chimpanzee as entirely lacking independent worth, as a mere resource for human use. He went on to say the issue of whether a non-human animal has a fundamental right to liberty protected by the writ of habeas corpus is profound and it's far-reaching, and it speaks to our relationship with all life around us. And insightfully, he wrote, we will not be able to ultimately ignore it. And he criticized the appellate decision, the underlying appellate decision we were seeking leave to appeal from, as being basically nothing more than a speciesist or human exceptionalism opinion. In other words, chimpanzees cannot have this legal right the NHRP is seeking for them because they are chimpanzees and not humans. That was kind of the essence of the opinion and the essence of what Judge Fahey was criticizing. So after we graduated from chimpanzees to elephants, we sued on behalf of Happy, who was a solitary elephant at the Bronx Zoo in New York State. And she was the first elephant to have a habeas corpus hearing. That occurred in 2020. And Bronx Supreme Court Justice Allison Tuitt wrote, this court agrees with the NHRP that Happy is more than just a legal thing or property. She is an intelligent, autonomous being who should be treated with respect and dignity and who may be entitled to liberty. She went on to say that the court was extremely sympathetic to Happy's plight, and I think that's an important word that she used, plight, because that evokes a very specific image, in my mind at least, as to what Happy experiences on a daily basis, really. She said they were sympathetic to Happy's plight and the NHRP's mission on her behalf, which was nice for her to say. Regrettably, however, she felt she was bound by prior appellate decisions dealing with non-human animal rightlessness cases, in other words, that we had brought that had been decided against us. She felt she was bound by some of the intermediate appellate decisions. However, the case was able to start to generate some support from experts in various fields: habeas corpus, civil rights, animal law, philosophy, religion, etc. Even some former judges got wind of this case and began to ask how they might be able to assist us. So, after this decision in the Bronx Supreme Court, which is the equivalent in New York of Hawaii's Circuit Court, we appealed the case. We lost in the Intermediate Appellate Court. Then we sought leave to appeal in the New York Court of Appeals, as we had done in Tommy and Kiko's case. And this time, they granted leave. Here's a rally we held for Happy outside the Bronx Zoo in 2022. Unfortunately, COVID interrupted some momentum that we had going for us. We were generating a lot of support in New York specifically. That is support at the zoo and at our rallies and protests. It seemed like more and more people were showing up to each one, so it was too bad when COVID ultimately happened. Oh, excuse me. I'm thinking about a different case. This is 2022. I apologize. Um, but with regard to Happy's case specifically, when the New York Court of Appeals did grant leave, it was the first animal rights case to be taken up by New York's highest court, which takes up less than 5% of cases that request to be heard. It was the first time that a high court of an English-speaking jurisdiction heard a habeas corpus case on behalf of a non-human animal. And at the May 2022 hearing, which I was able to attend, was covered widely by local, national, and international media. It seemed like every week there was an article about the case from various publications. It was really cool to see the publicity generated by Happy's case, because the publicity really was for Happy. Obviously, the Non-Human Rights Project was mentioned when these publications would write about the case, but they would always talk about Happy specifically and what she was forced to experience every day at this wholly inadequate space at the Bronx Zoo in the middle of a bustling, noisy city. And when you learn more about elephants, you realize that auditory assaults are some of the worst things that an elephant can experience in captivity, because they can't escape them and they have hypersensitive hearing. So yeah, it's a really bad situation. Happy's still at the Bronx Zoo today. We're constantly trying to figure out ways to help her. We're working on legislation with the New York City Council that would prohibit elephant captivity in the city. We're hopeful that might get another reading next legislative cycle. There are a lot of things going on for Happy. We haven't forgotten about her, even though we did not prevail in the case, as I'll discuss shortly. But we are always trying to help our clients, regardless of whether we have active litigation on their behalf or not. So one of the individuals who wrote about Happy's case was Yale historian Jill Lepore, and she said it was the most important animal rights case of the 21st century, which is, quote, a powerful statement. Her article was published in The Atlantic. You can still find her article today online. The New Yorker wrote about Happy's case. I'm not as familiar with the New York publications as my colleagues, but I hear that the New Yorker is a big magazine in that city. So that I'm glad to hear that there was an article in it about Happy. Here's a picture of the attorney who argued the case, Monica Miller. She's no longer with us. She is hugging our litigation director, Liddy Stein, who still is with us. I'll be seeing Liddy next week on our annual staff retreat. And then to their left is Steve Wise. He was our founder, as I mentioned at the beginning of the presentation. He's pretty sick at this time. None of us knew how sick he was. So looking back on this, it's kind of funny, kind of sad to know, and it's such his personality to have hidden a sickness like brain cancer from his colleagues. But yeah, he was a tough guy, and he wanted to see justice done for non-human animals. So he didn't want to take away from their plight with his own plight. He was an impressive person, to say the least. This is post hearing right here. Monica spent like 3, 4 months prepping for this case every day, all day. There's a lot that goes into just 10 minutes of argument. So we lost that case on behalf of Happy in a 5-2 decision. 5 judges voted to affirm the appellate court's decision to dismiss our case. And although Happy did not ultimately secure her freedom, we do view being able to walk through the New York Court of Appeals doors as a victory. At the end of the day, Happy had her day in court, And that's all that we ask courts when we bring these cases is just let their case be heard. Let us tell you what is really going on with these individuals and why you, you should do something for them. So I said it was a 5-2 decision, which means two judges dissented, and those judges wrote powerful dissents. I think that the combined pages for both dissents is something like 70 or 80 total pages, whereas the majority opinion is only a dozen pages. And I mention this because if you were to really grapple with the issues that we raise in our habeas corpus petitions, you wouldn't be able to write an opinion in just a few or even a dozen pages. You would need to take more time. You would need to evaluate the essence of our equality arguments, our liberty arguments, our arguments based on justice. You would need to evaluate what it means to be autonomous, what extraordinary cognitive complexity means in the context of non-human animal lives. And so seeing the dissents that much more thorough than the majority opinion kind of told us everything we needed to know, validated our approach. It allows us to now cite those dissenting opinions for persuasive authority in subsequent cases. And one of the dissenting opinions, the longer of the two, was written by Rowan Wilson, who is now the chief judge of the Court of Appeals. So uh, definitely a powerful experience reading those dissents, then reading them yesterday, reading them today. And it was the first such hearing, but it won't be the last. It wasn't the last. One excerpt from Judge Wilson's dissent says, "We should recognize Happy's right to petition for her liberty, not just because she's a wild animal who's not meant to be caged and displayed, but because the rights we confer on others define who we are as a society." And I find this to be the most telling statement in his whole opinion. The rights we confer on others define who we are as a society. It's so true. Judge Rivera, his colleague, the other dissenting judge, wrote, "Any myth that Happy is content in this environment is laid bare by the cruel reality of her existence. Day in and day out, Happy is anything but happy. There lies the rub. Happy is an autonomous, if not physically free being, and the law has a mechanism to challenge the inherently harmful confinement, and Happy should not be denied the opportunity to pursue and obtain appropriate relief by writ of habeas corpus. I dissent. A gilded cage is still a cage." Although I would argue that Happy's cage at the Bronx Zoo is not a gilded cage in any way, shape, or form, but I take her point. So where are we now? Well, inspired partially by Happy's case, Ojai, California became the first US city to recognize a legal right for a non-human animal when they did so on behalf of elephants. What this practically means is that elephants will never again be held captive in Ojai, California. They cannot be because elephants have a right to liberty in that city. And that legislation should really be credited to our Director of Government Relations, Courtney Fern. She does an amazing job with what little resources she has, and she was able to help successfully pass the first legislation of its kind in the country. And so we hope that other smaller cities, maybe some towns, will pass similar legislation, and we can build upon, increasing recognitions for the right to liberty for elephants, perhaps one day chimpanzees, and maybe eventually cetaceans and other clients down the road. When Happy's case was heard, we had already filed a case in California on behalf of three elephants at the Fresno Zoo. We took that case all the way to the Supreme Court of California, but the highest court dismissed the case without any reason. And I actually have that decision framed. I kind of use it as motivation. Let me grab it real quick. But I framed, you can't see it, but I have it framed right here. And there's just one line. It says the petition for writ of habeas corpus is denied. And I think that's, I think it's incredible that a court could dismiss a habeas corpus petition and say no more than that it's dismissed. There's so many things to be said about that, including judicial laziness. But we don't have to get into all the condemnation I have for the court of that time in California. I was able to argue a case in front of the Colorado Supreme Court on behalf of five elephants who were imprisoned at the Cheyenne Mountain Zoo in Colorado Springs. That occurred in October of last year, and that was a really fun and unique experience. I won't say it was an easy experience. The judges had a lot of questions and a lot of hostility right out of the gates. I think I got through maybe two or three sentences of my opening statements before I was being peppered with hostility, and I would go as far as to say condensation. Yeah, so but it was an awesome experience. I wouldn't trade it for anything. We filed our Hawaii case in November of 2023. We're now seeking an appeal in the Intermediate Appellate Court, or I should say, we're seeking a decision on our appeal. The case in Hawaii has been fully briefed since December of 2024, and the Intermediate Appellate Court has simply not done anything. And that was frustrating and a little bit infuriating for a while, but I have come to learn that the court takes a number of years before issuing a decision. So we are in a holding pattern in Hawaii, and that case was brought on behalf of the two elephants at the Honolulu Zoo, Mari and Vaiga, and we'll see what happens. And like I said earlier, in memory of our first NHR, in memory of our first client, Tommy, we brought a case in Michigan when we were able to identify where Tommy was being held. So Tommy, after our lawsuit in New York on his behalf ended, was bought by a roadside zoo in Michigan. Well, I guess the official documents say Tommy was bought. I think he was probably just given by his owner of the time in New York to the zoo in Michigan because he didn't want to deal with the craziness of litigation and some other things that were happening on behalf of Tommy. So we found where Tommy was being held. He was being held way up north in Michigan, kind of in the middle of nowhere at this roadside zoo I actually visited. And so we filed a lawsuit on his behalf, along with the other chimpanzees who are being held at the zoo. And we are waiting for the court to set a hearing date for our appeal, which is in the Intermediate Appellate Court. So we're at the same stage as Hawaii, just waiting for the court to say something. I will be lucky enough to argue that case in Michigan, and so that should be another fun experience. Specifically with regard to Hawaii, we appeared in front of Judge Gary W.B. Chang of the Circuit Court of the First Circuit. He was actually a very nice man. He was much more engaging than many of the lower trial or circuit court judges that we often see. He asked some really good questions. He asked some really probing questions that I did not expect. Um, I argued this case, and so I was the one that was able to kind of speak to the concerns that he had. But one of the things that he did say after we were able to acquire the transcript was that there's no doubt that elephants are incredible, miraculous creatures, but they are not Homo sapiens. So how does this court find and conclude that elephants are persons who qualify for habeas corpus relief? And that's an expected question, but it's still a good question. And he did make the concession that elephants are incredible, miraculous creatures, which he really couldn't have said if he hadn't read some of the scientific evidence we had submitted with this case. So I appreciate Judge Chang for actually taking the time to look at our case properly. He would go on to say, and the court is by what has been presented unable to find and conclude that under any circumstances, the two elephants in question could be considered persons within the meaning of the habeas corpus statute. And that's kind of what I alluded to earlier, this idea that elephants aren't persons, or chimpanzees aren't persons, or legal personhood means one thing, and elephants and chimpanzees mean another. And so, something that I kind of try and draw the judge's attention to is something that I'm going to read now for you. And this was from the concurring opinion that Judge Fahey issued in that motion for appeal that was denied back in New York. Judge Fahey, in his concurring opinion, wrote, the better approach, in my view, is to ask not whether a chimpanzee fits the definition of a person or whether a chimpanzee has the same rights and duties as a human being, but instead whether he or she has the right to liberty protected by habeas corpus. And that is the question that we are always trying to get judges to grasp. Do these individuals have a right to liberty based on theories of law that you seem to care about, like equality, fairness, liberty, justice? Do they have a right to liberty based on those theories in the same way that you and I do for the limited purpose of release from their confinement to a sanctuary, to a rewilding facility, somewhere that isn't a zoo, in other words, or private ownership in the way that Tommy was kept privately? And so if we can kind of reorient judges to that kind of thinking, I think maybe we'll have a little more success in the future. But I did have one last slide on my PowerPoint. I think I need to share my screen again. Okay. Okay. And I'd like to end these presentations with a quote from Obergefell versus Hodges, which was the United States Supreme Court case that legalized marriage for all Americans. And in that case, writing for the majority, Justice Anthony Kennedy said, if rights were defined by who exercised them in the past, then received practices could serve as their own continued justification, and new groups could not invoke rights once denied. Again, so true. I mean, we have to be able to evolve not only as a society, but as legal professionals, and the law itself has to be able to evolve. Otherwise, we would be stuck in bygone times, which weren't good for everybody. And so you can learn more about Happy's case at freehappynow.com. You can learn more about the Non-Human Rights Project at nonhumanrights.org, and you are more than welcome. And I would encourage you to email me at jdavis@nonhumanrights.org. I love corresponding with people that I've presented in front of. Sometimes, more often than not, I learn something. So don't hesitate to reach out. Please do. And I would love to chat. And I realize that's just under 35 minutes of a presentation. So hopefully we have some questions to kill some more time. But if not, I really appreciate you guys giving me the chance to speak in front of you.
Thank you, Jake. I know that was really interesting and insightful for me, and I'm sure our other participants would echo that sentiment as well. I'd like to open up the floor to some questions. I know that I have one, but I'd like to see if anybody else would like to ask anything first.
Yeah, thanks, Savannah. And thank you so much, Jake. That was really informative and inspiring. I appreciate everything you're doing. Here in Hawaii, of course, we've got a special fondness for cetaceans, dolphins, and whales. Is there anything of note that's happening on that front, or anything that you might suggest for us to consider? And I'll just note a little bit of bragging rights for Maui County, where I'm employed. We do have an ordinance that bans this. It's the captive entertainment of cetaceans. There was an effort to bring a SeaWorld type project here many years ago, and our county council enacted an ordinance to ban that, which I'm very happy about. Thank you.
Yeah, that's wonderful. If we can make that a statewide ban, that would be wonderful too. Actually, it's funny you mentioned that. Kind of an anecdote about where I live. Way back when SeaWorld was first trying to get its whales, there was there was immense outcry in the Pacific Northwest where they had captured a number of orcas, and when they finally were prohibited from taking whales out of the Puget Sound, they tried to go to Alaska, and Alaskans said, hell no, you aren't going to take our whales. And so, I mean, obviously Alaska and Hawaii are unique cases in the US in that we're not part of the mainland, and you can fly to one or the other pretty cheap, which is fun. But they also both kind of said, no, you can't take whales, which I think is an example that the rest of the country should follow, including California. But as to your question specifically, I've actually started communicating with cetacean scientists, so we're getting our orca case off the ground. I have a very rough draft of a petition that Monica, my former colleague, had drafted before she left. So I'm working through that, and I'm working with the experts to get their affidavits and declarations up to speed, because we're going to be going up against SeaWorld, and that's going to be a big lift. That's going to be a fight, because they, unlike most places we litigate against, will have experts who challenge our findings, and so there may be an evidentiary aspect that we haven't seen before in some of our cases. But as for what you can do, continue to support us in any way that you deem acceptable, and that support goes a long way to allowing us to do our jobs. And David, you've been a huge part of helping us in your state, so thank you very much.
Thank you.
I have another question too that I'd like to ask. I was wondering throughout your presentation, I know many of your clients are in zoos or like Tommy's case in the back of a small sad cage. So I was wondering if advocating for animals in laboratories poses its own issue, because I know there's really a heavy bias in favor of keeping animals in laboratories, especially for the purpose of medical research. So I was wondering if that presents an obstacle to your cases, or if you even are able to get to that point if judges are just ignoring that because personhood comes up way too quickly.
Yeah, that's a great question, and it reminded me that I forgot the most important part of the Hercules and Leo story. So Hercules and Leo were being held in a laboratory, and the lab actually agreed to release the chimpanzees of its own accord prior to our lawsuit concluding because of the public pressure that was being levied against it. And so, in some ways, one could argue that bringing cases on behalf of animals in laboratories may be even more viable than going up against the zoo industry. And we haven't brought further cases on behalf of um, individuals in labs, and that's because the US banned laboratory experiments on chimpanzees a couple years ago. So we haven't been able to identify a client, but if we expand our client base to another primate species, I think that bringing a case on behalf of lab animals would be a really good plan and one that we'll definitely discuss.
Do you think, just to follow up with that, that could kind of bring out a bias in judges to where they're saying that you're advocating for the personhood over animals, as opposed to whether you want to continue medical research for humans? Because I know that one thing I've experienced and seen in animal advocacy is when you advocate for the welfare or the rights of an animal, people often say, "Why are we putting this above people?" Kind of as a red herring there. So I'm wondering if that same issue might come up with that, or if you're concerned about that.
It very well could. That's a good point. I think the response that we would give a judge who made that comment would be something along the lines of, why can't we protect both? Why can't we protect the lab animal and the human? There are alternative methods of conducting these scientific experiments. And honestly, if I was in charge of the case, I would have an affidavit or I'd have a declaration from a scientist saying as much. So I could point to that and I'd say, Your Honor, with all due respect, the medical research doesn't have to stop today. We can continue it in another form, perhaps a more accurate form, and we can let this autonomous, highly intelligent creature who perceives the world like you and I do, who maybe had a family, maybe was taken from that family. We can let them go. We can give them the life that nature intended, something like that. So that's a really good, astute point. But I think we can counter it too.
Thank you. And do we have any other questions? All right. Well, if not, then I just want to thank you all so much for being here, and thank you, Jake, again. This has been really great, and I think this is a really great first CLE for our section. So thank you so much for your time, and I think you shared your email address with everybody. So if anybody wants to reach out with any follow-up questions, please, as Jake said, feel free.
Please, thank you so much for letting me chat.
Thank you so much. Okay.
Thank
Bye,
you.
everyone.